Last night, I attended a city council meeting where a room full of supporters showed up after three individuals during the previous meeting, one of which was openly carrying a handgun, demanded a council member resign because they didn't like two votes she made, even though she wasn't the only council member to vote against one of the decisions, and the other decision passed despite her valid concerns on the topic. Now, while he did have the legal authority to carry a gun into that chamber, in sessions both before and after demanding her resignation, he did not wear the handgun out in the open, leading to the natural conclusion that it wasn't in fact an intimidation tactic. Now, he claimed in this session that lambasted his behavior, that he wears the gun to protect himself. So let's, for now, ignore the fact that he wasn't at that time openly carrying, was in a council chamber surrounded by police officers next to a police station, and dive into open carry and self-defense. In the last video, I mentioned the Heller v. Supreme Court decision. It comes up here too because it referenced a pre-existing English right even before the Glorious Revolution. Now, before we continue, for those who don't know, the Glorious Revolution was in 1688 and was when England solidified their constitutional monarchy, where Parliament actually had the majority of power, rather than the absolute monarchy that had previously existed in places like France still existed at that time. So in the early 18th century, the scope of the right to actually have arms and the meaning of self-defense under that English law was still narrow, and it was more accurately exemption from prosecution. So the English Declaration of Rights affirmed the rights of Protestants to have arms, but did not sanction the use of deadly force in most circumstances, and didn't even imply a right to own a gun in most situations. You just couldn't be prosecuted for homicide and self-defense as long as you were legally entitled to possess the weapon, which at that time was limited by class and religion and subject to parliamentary regulation. Over the next 50 years, this got expanded to allow ownership of a gun in the actual home for reasons of self-defense, but that was not, as Heller stated, in the English Declaration of Rights back in 1688. Even when it was deemed legal, the right to carry arms in public remained narrowly defined and limited to a specific set of situations. The right to travel armed for reasons of self-defense was always balanced against the need to preserve the king's peace. The game laws of 1692 regulated hunting. Even they had stiff penalties on the possession of guns for those who failed to meet the property requirements of the acts. So the House of Commons actually considered and then rejected by a 2-to-1 majority a rider to the act that would have allowed any Protestant to keep a musket in his house, notwithstanding this or any other act. In other words, the House of Lords actually called the idea too radical because it tended to arm the mob, which, as you may remember, was a sentiment echoed by our founding fathers during Shays' Rebellion in 1786. Since these documents were the ancestors of the Constitution, the fact that the preservation of peace trumped the right to have arms, we discussed in the last video, is familiar, right? So another misused and truncated quote is from George Mason, from the Virginia Ratifying Convention, which you've probably heard of, but what it actually says is this: I ask, who are the militia? They consist now of the whole people, except a few public officers. But I cannot say who will be the militia of the future day. If that paper on the table, meaning the Constitution, gets no alteration, the militia of the future day may not consist of all classes, high and low, and rich and poor, but they may be confined to the lower and middle classes of the people, granting exclusion to the higher classes of the people. His statement was in response to Article 1, Section 8 of the Constitution, which gave Congress the power to provide for organizing, arming, and disciplining the militia. His fear was that if Congress had that power, they would decide to only conscript the poor into service. He clarified that a government that is too small and too far away from the people it represented would result in representatives having no fellow feeling for the people. He was afraid they would put forward ignominious punishments and heavy fines on those who chose not to participate in the militia or exempt people in their own class from service, which unfortunately is kind of the case now. But anyway, this led to him proposing the clause exempting the militia from martial law except when in actual service and from fines and punishments of an unusual nature. So again, as stated in the previous video, this was, of course, specifically speaking to white males. Mason was talking about ensuring the government provided the militia with arms, training, and discipline, as those are, in fact, necessary for a military unit to function. Makes sense. As we discussed in the Founding Fathers and Guns video, the Second Amendment was never about overthrowing our own government. In fact, interestingly enough, in 1836, when Massachusetts law expert Peter Oxenbridge Thatcher advised that no person may go armed with a dirk, dagger, sword, pistol, or other offensive and dangerous weapon without reasonable cause to apprehend an assault or violence to his person, family, or property, the press actually at the time called it sensible, practical, and sage. Wisconsin, Maine, Michigan, Virginia, Minnesota, Oregon, Pennsylvania all passed laws restricting public carry. The South, as usual, had a different perspective, and in 1850, Louisiana Supreme Court opinion explained that carrying a concealed weapon gave men secret advantages and led to unmanly assassinations, while open carry placed men upon an equality and incited men to a manly and noble defense of themselves. Some Southern legislators passed laws permitting open carry, but punishing concealment, and other Southern courts actually followed their lead, opposing concealed carry, which they deemed unmanly and not constitutionally protected. While the South was encouraging openly threatening each other with deadly results, the North was baffled by what in 1845 New York law expert William Jay called those portions of our country where it is supposed essential to personal safety to go armed with pistols and bowie knives. Flash forward to 1997, where a study by John Lott and David Mustard, two University of Chicago economists, concluded that right-to-carry laws were the most cost-effective method of reducing crime thus far. A 2004 National Research Council report debunked their claim that these laws reduce violent crime, in fact showing the opposite was true, much like it did in the South back during the Civil War where it started. Right to carry leads to higher rates of violent crime. The National Bureau of Economic Research, a nonpartisan group, produced a comprehensive study in May 2017 that had 14 years more data and 11 more states, and found within 10 years after the adoption of right to carry laws, violent crime was 13 to 15% higher than it would have been without the law. Just 5 years after, it's about 7% higher. They determined this by building synthetic states as near identical counterparts to the 33 that passed right to carry laws between 1981 and 2014. Using the state's crime rates prior to the law's adoption, as well as national crime data from before and after, their algorithm actually estimated what trends would have been prevalent had these areas never passed right to carry. They then compared crime in the real states with findings from their synthetic versions and wrote, "There is not even the slightest hint in the data that these laws reduce violent crime." Now, you might think 7, 15%, that doesn't seem like much. In reality, however, the average firearm mortality in these 50 United States was 670 in 2014, 722 in 2015, 771 in 2016, and 793 in 2017. That goes from the highest, which is Texas, around 25 to 3,000 deaths every single year, down to about less than 50 for states like Hawaii. It has climbed every single year, so let's assume the lowest, 670. A 7% increase would be 50 more people dead in each state, so 2,500 additional American deaths. A 15% would be 100 more people dead in each state, so another 5,000 Americans. This is where I let you know that using CDC data from the beginning of 2014 to the end of 2017, 147,864 Americans died from firearms. A high-profile killing in Minnesota early in January 2018 offers a really good example of right-to-carry laws leading to more violent crime. A 25-year-old, who I will not name, no notoriety, had a bumper sticker on his car that read, "Gun control means hitting your target," was arrested for shooting 17-year-old Muhammad Rahim to death after a traffic accident. Witnesses described the two young men as confrontational, and the gunman claimed he was acting in self-defense. John Donahue, who is a legal researcher at Stanford Law School, explained that the most obvious problem is people get into disputes that without guns would at the most lead to a bloody nose, and that if one or both parties are carrying guns, such conflicts now lead to death. We've seen this also in road rage incidents. While impulsive violence is an issue, the bigger problem is that when you start carrying guns, you make them much more likely to be stolen. And in fact, Brian Frescos at The Trace, who kicked off a November investigative report on the way that stolen guns have become a major component of the gun crime problem, actually demonstrated that American gun owners, preoccupied with self-defense, are inadvertently arming the very criminals they fear. He found out that more than 237,000 guns were stolen from legal gun owners in 2016 alone. And that's quite frankly a drastic underestimate, more than likely, as most gun owners don't actually report thefts to the police, and there's no legal requirement in most states to do so. One reason gun theft is so common is because our toxic gun culture actually encourages gun owners to have their firearms accessible at all times, whether in cars, homes, or on their person. If people actually did keep guns locked up, as responsible firearm owners did for generations, and which is still encouraged on military bases, guns wouldn't be the easy targets they are today. Reliable estimates actually put 3.5 million stolen guns entering the black market over the past decade. Now, the NRA and their lawmakers have been pushing permitless carry laws. Getting a concealed carry license in many states is actually exceptionally easy. It's often less than 30 minutes to complete an application. Some states don't even require spending time at a range to learn to use it. Some don't even require those permits. Now, the NRA has lobbied hard to even get those restrictions in place lifted, including further lowering or removing fees for licenses. Guns may make a small percentage of the population feel safer, but all of the evidence actually suggests it makes society less safe, especially everyone who isn't a white male. Unfortunately, we have several examples of this. The now 3-year-old shooting of Philando Castile, a black man who had a concealed carry license and was murdered in his car in front of a child in the back seat by a police officer. Saheed Vassell, who was killed holding a shower head that looked like a gun. Tamir Rice, 12 years old, murdered within moments of a police officer arriving at a park, and even though he didn't have an actual gun, it was an open carry state. Same for John Crawford holding a gun that was sold in the Walmart in an open carry state. Keith Lamont Scott, North Carolina, also an open carry state. Gunned down for not dropping the handgun he was legally allowed to carry. Yet there was no uproar from the NRA over the right to carry in order to protect themselves. That's just a small hint of the disparity between the right to carry and the actual reality of gun violence in America. I'll put some links that I do suggest reading in the comments. Thank you.